Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Welcome to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion in estate planning. Attorney Thomas D. Begley III is a certified elder law attorney with over 30 years' experience helping families protect their legacy and prepare for life's toughest transitions. I'm Zofia Morales, and today we are asking the question many people don't even realize they should be asking. Today we're discussing, is a will enough? The need for lifetime planning. Welcome back, Tom. I'm so happy to dig into this issue with you today.
I look forward to it, Zofia. So fire away.
All right. So if I'm looking to get my affairs in order, and I probably should be, I'm getting up there, what do I need in addition to a will, if anything?
Okay, well, I tell people that everyone should have three core documents. The first would be obviously will, because that says where your money is going to go when you're gone, and it appoints the person that's going to get it there, your executor. The second is an advanced medical directive. An advanced medical directive can come in three forms: a living will, a healthcare proxy, and healthcare power of attorney. Quite frankly, the healthcare proxy is a relatively useless document, and I haven't seen one of those used in years. So the living will basically states how you want to be treated in the event you can't make medical decisions yourself and you have a life and death decision ahead of you that involves whether or not with life-sustaining treatment should be withheld or withdrawn. And the healthcare power of attorney provides someone to step into your shoes to make not only that decision, but other decisions if you happen to be incapacitated and can't make medical decisions anymore. And then a power of attorney, typically the financial power of attorney, typically a general durable power of attorney, is a document that trusts somebody to make financial and some personal decisions on your behalf between now and the time you pass away. And basically, you want to make sure your estate plan takes care of you from the day that you sign it until the day that you're gone and beyond.
Okay. So it's not just about when I'm dying. It may be about those critical years or months that are leading up to that point as well.
Absolutely true.
So what sorts of documents do I need to take care of me right now? What happens if I become incapacitated and I don't have these in place? You mentioned a living will and a healthcare proxy and I've forgotten all of the terminologies.
Yeah, so the documents that take care of you while you're alive are the advanced medical directive and the general durable power of attorney. And to be clear, what I wound up doing in my office, some people actually draft two separate medical directives. And I can tell you from experience, that's not particularly practical. I remember many, many years ago when my wife was pregnant with our middle daughter, she wound up having early labor and went into the hospital multiple times. And I remember it's difficult enough for me to remember bringing one document. The idea of having to bring two would have been insurmountable. So, I mean, I was going in and out the last few months of pregnancy. I was like Norm coming in and out from Cheers. So it's important to make sure, in my opinion, these documents are merged together. The other thing also from a drafting standpoint, every so often I see somebody that puts the healthcare powers in the middle of a general durable power of attorney. I can tell you that any doctor you talk to will say that they do not want to be rooting through a 15 to 20 page power of attorney to find out where the medical provisions are. And I will tell you, every time I've looked at them in a power of attorney, they're always in the middle, smack dab in the middle. They're never like at the beginning or the end. So doctors are in a rush. You need to make their job easy. Put it all in one consolidated document. Now, if you don't have a living will and a power of attorney and you become incapacitated, then you have to have a guardianship established. And a guardianship is what we call court-appointed surrogate decision-making. So rather than you having made the decision yourself, the court is going to appoint somebody to make decisions for you. Now, typically, the person that petitions to have a guardianship established is a spouse or an adult child. But, for example, county agencies in New Jersey, Adult Protective Services, can file a petition if they think that there's nobody in the family qualified who has been stepping up to take care of a vulnerable adult. Also, I've represented hospitals in the past because, that have decided to file a petition to make sure that proper care was given. But probably 98% of the time, these petitions are originated by family members. The issue is that the court's going to appoint someone who may or may not be who you would have chosen. And then the cost is substantial. I mean, power of attorney and healthcare directive could be hundreds of dollars. A guardianship in Burlington County, where I'm located, probably when you throw in the doctor's reports and the costs of the petitioning attorney and the court-appointed attorney can easily exceed $5,000. So just from a sense of common sense, a few $100s is certainly a lot cheaper than a few $1,000s.
Yeah, absolutely. And I imagine it would kick in a lot more rapidly than having to like push this through the court system. How long does it take to get a guardianship done?
That's an interesting question. Depends on the county. Some are a little quicker than others, but on average, it could be a couple of months. So let's
Wow.
say I had to apply for guardianship on behalf of one of my parents, and I filed the papers today. I probably get a court date back in about a week, but the court date's going to go out for about 7 to 8 weeks
Mm,
because three things have to happen between now and the time they would have a hearing. One is that people are presumed to be competent and they have to get served just like anybody else in the proceeding. The second is anybody that has what's called equal or greater statutory priority has the right to be notified. So I'm one of 5 children, and if I had to petition for one of my parents to be their guardian, I'd have to notify and certify in regular mail all 4 of my siblings what my intentions were to do. And then, because let's say the other parent's not going back, if they have a higher priority, I have to notify them. The third thing is that the court appoints an attorney to represent the incapacitated person. Historically, it used to be to make sure that everything was on the up and all the I's were dotted, T's were crossed, but nowadays that they also will act as an advocate to make sure that person's wishes are expressed. So when all is said and done, oftentimes it's a couple of months from the time you file the complaint to the time that you wind up getting the permanent appointment. And that also doesn't take into consideration the fact that if you come to my office today, within a few days you can come back and sign your advance directive.
yeah.
If you need to get a guardianship, I have to get 2 doctors to certify that you're mentally incapacitated, and those have to be relatively contemporaneous certifications and have other paperwork, and that could take a few weeks. So really, that 2-week process, 2-month process could be like 2.5 months. There is one exception that's called a emergency medical guardian. That's can be achieved, but it's very, very stressful to get those,
Mhm.
and it costs even more. So
Yeah.
I can't emphasize enough for people to make sure that when you can, you have your affairs in order.
So I know there can be some anxiety around like signing a power of attorney. Am I giving up all of my control and power over my healthcare and my finances when I do something like this?
That's an interesting question. So under the healthcare power of attorney, the law is really strict. Uh, Nobody can make a medical decision for you, even if you have executed an advance directive, unless 2 doctors determine that you are unable to make medical decisions on your own. So, and my experience with the medical community has been very strong. They will do anything to try to ascertain somebody's wishes before they would look to somebody else for that input. Now, on the other hand, a power of attorney from a financial standpoint, the general durable power of attorney being the most popular, those can be what's called springing powers of attorney, but most of us have them that they're effective immediately. People used to do springing powers of attorney, and that would mean that nobody could act on your behalf unless you were declared incapacitated by a doctor. The
Mm,
problem is doctors have a lot of paperwork they have to do to begin with, and if you need to get a doctor to sign the appropriate forms to be able to use the power of attorney, that may take some time.
yeah.
Also, the reason why people would want that protection is because they were concerned about their agent possibly mismanaging or misappropriating their assets, to which my simple response has been, if you have that level of concern, you need to pick somebody else.
Yeah.
So the reason people, though, do have basically somebody picked to be an agent under a power of attorney immediately is for a couple of reasons. One is to make it easy. Nobody looks at having a power of attorney as, giving someone a favor to be their agent. I've served as an agent under power of attorney. I've never looked up in the skies and thanked the dear Lord that I had the ability to serve on somebody else's behalf. It's, a task. So you want to make sure that if you're asking somebody to do this, you're trying to make it easy as possible. But also, the power of attorney can be protected first. You have the ability to make your own decisions under a power of attorney. So you don't give up anything under that. You have the ability to continue, but your agent can act on your behalf if you're competent, so long as you delegate to them and say that it's okay. Or in the alternative, if you're incapacitated, they can certainly step in and make those decisions. But in order for someone to use the power of attorney, and this is where I calm some people that have some understandable fears, is you not have to just name them. You have to give them the documents. So hypothetically, I'll pick on my father today. If I were to, go to the local bank and say, I'd like to get $50,000 out of my father's account, they'd say, where's the power of attorney? And I don't have that on me. So if you don't give it out, the person can't use it against you. So I typically recommend the clients let people know that they're going to be the agents under your power of attorney or the healthcare representatives under your advanced medical directives, but just let them know where the documents are. Don't give them out.
Yeah, okay, that's some solid advice. So to make this easy, can I kind of lump all of this into a simple form, or how best to approach this sort of thing?
So as far as a simple form, it's kind of an oxymoron when it comes to law. It's especially because things have become more and more complicated over the years, and people are always aware of this happening from the government or this happening from a lawsuit, and they want to make sure that everything is possibly covered. I think with an advanced medical directive, I'm very much against the forms that I see. I think they're well-meaning, but a lot of them have check the boxes. And when I've reviewed them for clients, many times they don't realize what they're doing. And for example, in New Jersey, in order to have life-sustaining treatment withheld or withdrawn, 3 things have to happen. 1, a terminal condition or persistent vegetative state. 2, no hope of recovery. 3, no quality of life. I mean, you really have to be at the bottom of the proverbial barrel.
Right.
However, when people fill out the documents, by the time they get to what they want, what they don't want, they'll say that I want to have CPR. I want to have I want to have antibiotics. They want all these things. And then when you ask them, well, do you want these if you were going to die anyway? And they're like, oh, no. They just thought, well, if I had a heart attack, I want to have CPR. But so the documents aren't well explained. And a lot of them are not written particularly well. There were 2 studies done over the years by renowned hospitals, one in the 90s and one in the 2000s. And they both came out with the title, Why Living Wills Don't Work. And, the simple answer was because the documents were not prepared or explained properly. So I do think, you don't have to spend an arm and a leg. If somebody wants to charge you an arm and a leg, they're not the right person to use. But for relatively inexpensively, you can get a very good healthcare directive, for you. And as far as the powers of attorney, I think it's imperative that you have something that reflects your background. I've seen really powers of attorney fall into 3 categories. One is for most of us, and that's where we put in, I call everything but the kitchen sink, because sometimes our lives change. I told people years ago I had an 85-year-old woman come in, and she was a depression era baby, and at the age of 85, she decided it's finally time to get out of the CDs and into the stock market. And I remember once I had an 81-year-old that became a first-time home buyer. So if we didn't have the provisions to do those things and they were incapacitated, we wouldn't have been able to do it. So I always tell people to err a little bit on the side of too much. But I do think, for example, someone that's very, very modest assets, they don't need to have an overblown power of attorney. And there's a simplified form that does work for them. But on the flip side of the coin, if somebody has business interests, you need to have something that reflects those. Right. And a lot of times people think business means you're some really rich Wall Streeter. But there are a lot of people that are simple folk off the street that have their own business and doesn't have to be worth millions of dollars. But you need to make sure that if something happens, that somebody can step in and handle those business decisions.
Yeah, exactly. Help to manage it, make sure the payroll happens and the taxes. Yeah, absolutely. Well, thank you for sharing all of this with us today. This has been very helpful.
Okay, my pleasure.
And thanks for joining us on the Estate Blueprint. As you heard today, a will is just one piece of the puzzle. Lifetime planning tools like powers of attorney and medical directives are critical to protecting your wishes and your well-being. To get started with your own estate plan, visit Begley3law.com. And if this episode helped you to think differently about your future, please subscribe, leave a review, and share it with someone you care about.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.